We're going to have a session on the legal side of this. We've touched on it already, but it's to bring us up to speed. We have two people who know more about it than most of us. So Paul Jenkins, next to me, QC, member of Matrix Chambers, is someone who's advised on public constitutional and EU law. Next to Paul is Rob Murray from Michigan Derrea. Now, Rob's a partner there. They're sponsors of this particular event. Thank you, Rob. And Rob was one of the two main partners advising Gina Miller in relation to that Article 50 challenge, which was successful. So Rob's an expert on European law and competition law in particular. Well, the aim now is to sort of get a general understanding of the legalities of the negotiating processes. And we'll sort of start with the EU level, and then we'll have a look at the domestic level. So maybe, Sir Paul, you can take a few minutes to talk us through the legal scene over the next 2 or 3 years at the kind of the international level as opposed to domestically.
Thank you. I'm just to put a bit more context. It's always nice that people mention I'm at Matrix Chambers, and if my practice manager's here, he'll love that. Critically for this, I was also the Attorney General's Permanent Secretary until 2014, having spent most of my professional career in the civil service and done a lot of negotiations in Brussels. So it's that as well, but okay. Thank you for mentioning Matrix, because we what I thought I'd do, I don't think for the purposes of a forum like this, going into a huge amount of legal detail is hugely valuable. I think what we need to move on from that, but I think it's very important as you move on, as we seek to influence, you seek to influence both in Brussels and in the capitals, the rest of the capitals of Europe and in London, that you have in your minds at least the legal framework within which we're operating. If in the course of those discussions details come up, then you have to ask. So I'm not going to sit here and give you a 2-hour legal lecture on all the different things. I'm just going to try and set it in a bit of context. So the headlines around what I'm going to say for the next 5-10 minutes are that by March 2019, a date we all recognise, we need agreement which covers 3 things. We need an agreement which covers the process of withdrawal, so what everyone calls the divorce, an agreement that covers a framework for future relationships, and I think very clearly, and everything Stefan and Jonathan said confirms in this view, we need a transitional package to bridge the gap between withdrawal and the long-term deal. If we don't have anything to bridge that gap, that would be almost as catastrophic in the short to medium term as no deal at all. And then what I want to do is look at the next 2 to 3 years, which is not a very subtle way of taking us from the Article 50 process, the 2-year withdrawal process, into the beginning of the long-term negotiations about the future. So as we move into the 3rd year and beyond, we will need to negotiate, as Stefan and Jonathan have said, a long-term agreement with the European Union, critically building on the framework agreed under the Article 50 agreement. Okay. If anyone's got questions as we go along, do shove your hand up. Let me say a bit about timing, and again, this has already been touched on. As I think everyone knows by now, Article 50 gives 2 years to conclude a deal, or critically, all the EU treaties cease to apply to the UK overnight. It's the so-called, it's what everyone calls the cliff edge Brexit. Get to the end of the 2-year deadline, and absent an agreement with all 27 states, we fall off the edge. Frankly, I think most people, most rational people regard that as a catastrophic outcome for us. It's a bad outcome for the EU, I accept that, but it's catastrophic for us. They can live with it. We would really struggle on that. So I'm going to concentrate in most of what I say on the situation where we are moving towards getting a deal rather than catastrophe. Just Article 53 allows for the 2 years to be extended if all 27 member states agree. Nobody will want to extend it, and actually, critically, we need to recognise that the real negotiation period is much shorter. We haven't started yet. All we've had at the moment is rhetorical posturing on both sides. One of the things I would have asked Jonathan, actually, just in passing, you talked about, you and Stefan talked about how far the 27 would box themselves in with their negotiating mandate. I think it'd be very interesting to see how far further we go boxing ourselves in and the launch of the Tory manifesto in half an hour. We saw some red lines set out by Theresa May in the Lancaster House speech. If she strengthens some of those red lines, I think it'd be even harder for her to row back on that. And I think particularly if she strengthens the red line around the role of the court in Luxembourg, then we're heading for real trouble. But as I say, timing, we've got 2 years. Actually, we haven't started yet. Something will happen, as Stefan said, before the German elections. But let's look at the other, don't forget the other end of the process, the Article 50 deal. Theresa May has promised a vote in the Westminster Parliament. There has to be an approval of the European Parliament, so we've got to factor in, I would say, 6 months or so at the end. So the reality is we've got about 12 months to do this. And that's a very, very short period for a massive task. So let's be clear, the Article 50, let's focus just for a second on Article 50 and what it won't deal with. It won't cover the long-term relationship. I don't want to give you a legal lecture, but Article 52 says an agreement with the departing state setting out the arrangements for withdrawal. That's one set of keywords, the arrangements for withdrawal, so the process, the mechanics of the divorce, taking into account, quote, the framework for its future relationship. So there's the divorce thing, and then there's a framework for the future. If you want to flog the divorce analogy to death, you've got sorting out the money, that's the arrangements for withdrawal, and then you've got a high-level agreement about who has the kids, 50% here, 50% there, and they'll probably go to a private school or a state school. Moving on to the framework for the future relationship, you begin to, as I say, that's there, that comes there, and it sets out very high-level principles of the sort I've just talked about, who's going to do what in the future. But it doesn't cover, and it can't cover, the long-term detailed settlement, only the framework. And that's where, in the last year, everyone, other than some sort of Euro anoraks like me, everyone suddenly heard of Article 50. Everyone talks about Article 50 now. Trust me, fairly soon everyone's going to be as fascinated by Article 218 as they are about Article 50. And all sorts of other things, the Common Commercial Area, Article 207. We're going to become experts at that little section in the Lisbon Treaty. So we'll move for a long-term deal to Article 218, and let's be clear, whatever the rhetoric, and I'm pleased that Stefan and Jonathan agreed with this, it will be almost impossible to agree a detailed long-term settlement in time for the end of the Article 50 period, and that's why we'll need something to bridge that gap. And that's why a transitional deal is so important, and I think probably one of the most difficult things to pull off here. Just one point to watch on transition, and sorry, this is a bit legal anarchy, but it is quite important. And it ties in with a question we had about the Singapore case. What is the legal basis for a transition agreement? A transition agreement, as I say, bridges the gap. I'm sure if we conclude one, it will see phasing in and phasing out. It'll start from something pretty close to the status quo, and it will provide that within 5 years we'll have managed down to something much less than the status quo. The critical issue is what is the legal basis for concluding that deal? If it's Article 50, and there's a very good argument which the British government lawyers accept and the German government lawyers accept, that you can use Article 50. That's good, because Article 50 has a special, streamlined, quite comparatively easy approval process. The Walloons don't get a look in under Article 50, okay? If you move towards Article 218 and say, actually, the transition agreement itself, which will inevitably be a mixed competency agreement. If you move towards that and say, actually, it's more 218 than 50, then the Walloons start getting very excited. And I think, in answer to the question from The Guardian about the Singapore agreement, it has the potential to make things marginally easier. Well, we're all still trying to work out what it really means, but the best I would put it at the moment is marginally easier.
So can you just remind everyone what 218 actually says?
Where's my laptop? 218 is a general provision in the Lisbon Treaty which deals with arrangements between the European Union and third countries. And when we leave, at the end of the 2-year period, which we will do, absent an extension, either with an agreement under Article 50 or over the cliff edge, we will at that moment become a third country. So any deal between us and the EU will have to be concluded under 218. If you want me to go into any more detail about the different voting mechanisms and different bits of Article 50, I'll write to you later, Minister. Everyone talked, the previous panel talked about phasing. I think that's the next thing to watch, sequencing or phasing. Sequencing so far has focused on issues that both sides seem to accept come first. So money, EU residents and the land border on the island of Ireland. Of those, just to bring it back into the wording of Article 50, money is part of the withdrawal arrangements. It's not part of the framework for the future, unless we agree for the future to pay into something like Europol. I mean, everyone seems to accept we've got to hang on to Europol. That's not going to be a free ride. So there will be a bit of money into the future, but Article 50, basically, the money is part of the withdrawal arrangements. The 27 have made it very clear, Barnier has made it very clear, that the rest of the future relationship won't be discussed until there's been substantial progress. And that's obvious, that's one of their best negotiating cards, so why would they give that away? And at the moment, the Council of Ministers have made it clear they won't even agree negotiating mandates, either for transition or for future arrangements, until substantial progress has been made. So they're not even ready, they're not even near the starting line on that at the moment. But apart from the money, the critical sequencing legally and logically is that you can't conclude a transition deal until you know what the framework looks like. I mean, one of the things that David Davis has said, without being too political, one of the things he said that actually does make some sense, and I think Jonathan made the same point, although he wasn't as rude about David Davis, obviously, because he's much more polite than I am, is that actually you do need to have some sense of the long-term destination before you can work out how you're going to get there. Obvious, isn't it? So what will be in any agreement, briefly? The framework will need to cover much more than just citizens and the Irish land border. Every sector in this room will need to be covered by it. It'll need to cover security and intelligence cooperation, data sharing, movement of people. It'll need to articulate high-level agreement on principles like state aids. What are we going to do about that? It'll need to address dispute resolution. Every agreement has a dispute resolution mechanism in it. Is it going to be the ECJ? Will we find that, where's she doing this day? Halifax, Huddersfield, somewhere in the north. Halifax. If she boxes us further in on the ECJ, there's going to have to be a lot of creative thinking about whether you can somehow suck the EFTA court into this, whether you can come up with the same weasel word, she'll hate this, that we have for the Convention on Human Rights, which is the British courts take into account the jurisprudence of of Luxembourg, rather than be bound by it. You know, you can see there's scope for movement there in areas that will be inimical to the heart of Theresa May. So it's a massive spread, and critically, as I say, article will only deal with the framework. But the transition deal needs to cover everything. It's got to be a comprehensive bridge that covers everything from the moment we leave to the moment we have a full long-term deal. And this is where, I mean, to illustrate the point, the easiest way to understand it, but it won't happen, is you take the status quo and you turn that into the transition agreement and say, on day one of our life as a third country, nothing has changed. But as we move through the framework for future agreement, over the next 3 to 5 years, gradually you phase stuff out and phase stuff in. Now that is actually an unrealistic scenario because the government cannot, I don't think, can possibly accept the status quo. So there'll be something short of the status quo as the starting point. One of the things I'm supposed to talk about at some point is what the deal is going to look like. Forget it. You know, you talk about that now. I don't think anyone has any idea. I said, just finally and briefly, no deal is catastrophic, but I think we all need to keep an eye on this. Not least because the worst nightmare in Whitehall, the thing they all talk about in terms of capability and capacity, is the need for twin-track planning. So they have to put huge amounts of work into negotiating a deal, trying to get a deal, and putting in place the legal building blocks to give effect to that legal deal, which is something Rob's going to talk about in a minute. But at some point, they've got to say, well, actually, there is a prospect, and it will be there right till the end, because there's no deal till it's all done, that it doesn't happen. So at some point, I want someone to stand up and ask David Davis, when are you going to begin contingent bilateral relationships with the United States for a UK-US open skies agreement? Otherwise, on the day we leave the European Union, there is no legal basis for planes to fly to the US. And when John Wood, I say this, and John Redwood on a panel when he said, oh, don't be ridiculous, of course they'll carry on flying. Is anyone here from the insurance industry? You wouldn't insure a plane if there was no legal basis for it to take off, okay? So they've got to begin that twin-track planning, and a nightmare. Okay, just 3 very quick legal points. An Iraqi point, I said the Article 50 deal has a special agreement procedure, which is good. It's agreement is by what's called a super qualified majority, which basically means 75. It has to be agreed by 75% of the member states, excluding the UK, representing at least 65% of the population. Okay, so it's bigger than a normal qualified majority, but it's not a simple majority. I'm often asked if we can change our minds. I know we're not supposed to be looking at, undoing this. The consensus seems to be that if everyone agrees, the 27 agree, we could change our minds. Much more difficult if we want to unilaterally change our minds, but there are cases going along which might test that. And finally, just in case we change our mind after we've left, Article 55 says we can rejoin using Article 49, which is the process that you use for joining the EU in the first place. Okay, sorry.
Right. So I just want, on the transitional arrangement, in a way, here's the question. How long is that? Is that going to look like CETA? No, because CETA takes 5 years to negotiate. It actually takes us back to something which our friend from Linklaters was suggesting, which is cut through all that complication, just have something much simpler, and which is, sort of outline agreement. And then the question is, if you can do the transitional agreement within the 2 years, why don't we just say we can do the whole thing in the 2 years? Because if we can agree the transition, then you've done it, haven't you?
Of course, it's a very good question. And that's why I gave what is a slightly sort of fanciful example to illustrate the starting point for this, because I can't really answer your question, of course, because nobody can. But if you think conceptually, the starting point for transition is basically taking the status quo that exists the day before we leave and carrying it forward into a full transitional agreement. That politically won't fly in this country. So you start playing around at the edges. So you part of the negotiation, I suspect, will be how, once we know roughly what the future arrangement is going to be, how you begin right from the start to modify the status quo in the transitional agreement. And then the transitional agreement has to provide a mechanism for a starting point somewhere, basically the status quo, but something short of it to meet British political needs. And it's going to then have to provide how you manage that down. And it'll have to have a fixed time. I think one of the advantages that the Prime Minister has gained for herself by calling an election is she's got off a general election coming so soon after the 2-year period. We've still got the European parliamentary elections in 2019. We've got to be out by then, otherwise we'll have the farce of re-electing Farage and people to the European Parliament. But she hasn't got to face an electorate in 2020 with a transitional deal that's got 5 years to run. It gives her a bit of breathing space around that.
I just want to ask you one other one. What's the difference between the EFTA Court and the ECJ? What does the EFTA Court look like? What is it? Are they legal bodies appointed from around Europe? Is it sits once a year and just...
I mean, it's not my area of specialism. They're not that different. I mean, I think in terms of the conversation we're having, the critical difference is one of perception.
Yeah.
It's
judges, foreign judges, basically.
It is foreign judges, but it's got a different badge. All her rhetoric is around the court in Luxembourg, not the EFTA court. I was talking to a very senior EFTA official the other day, and I said, do you really want us? Because it is the easy way to solve it. Do you really want us? Do you want the troublemakers in? How would you cope with a country like us who is stroppy?
Will be three-quarters
And he
of
said
the
it was a
caseload.
wonderful quote. He said, we cope with Switzerland. So he said, if we cope with Switzerland, we can cope with you.
Right. Okay, so that's the... that, if you like, gives us some background. We'll take some questions in a minute, but I want to ask Rob to sort of talk us through the sort of UK side of this, where we've had the Great Repeal Bill as the answer to most questions about what are the legal processes domestically. Fill us in a little more detail.
Well, I suppose at the top level, what happens in the UK has to mirror where we get to externally. The Great Repeal Bill, 3 words, 4 syllables, one of which is ambiguous, one of which is misleading, one of which says what it does on the tin, which is the word bill. The ambiguous one is great. The misleading one is great coupled with repeal, because the repeal bit is a small part of what the bill does. Most of the bill will be actually trying to maintain status quo and Paul raised an interesting question, how much of the status quo is going to be maintained right from the day one of drafting. So the objective of the Great Repeal Bill is to achieve legal certainty, mindful that life has to go on, particularly business life. So the idea is that we don't have the cliff edge where on Brexit +1, B+1, we have a huge gap in our law because we haven't managed, for example, to do a deal that covers everything it needs to cover. The repealing function is this is the implementation of the referendum result. This is Brexit. It's the end of the supremacy of EU law, and in particular, it's the end of the role of the European Court of Justice as a supreme body in our constitution, including European law. So at one level, it's kind of taking with one hand and giving back with the other, bit of a sleight of hand. The real question is, well, what's the content going to be and how does it work in detail? Now, the government white paper says, don't worry, on B+1, we'll have the same laws, which is not true. They will look similar, but they won't be the same from a legal perspective. So it's important to realise that this bill doesn't deal with things that have already been put into national law, which is generally directives that have been implemented through national laws. It's actually the treaty rights and what EU lawyers call the directly applicable rights that are being pulled over into national law. And on the face of it, they might look the same. The words might be the same, but the critical difference is that, unlike B-1, those rights are not guaranteed by a supranational court over and above the power of Parliament or indeed the English courts to decide the same issue. Nor would it be possible if, for example, one felt that the government was was misimplementing, if you like, a right to ask the European Court, well, did they get it right or did they get it wrong? So from a lawyer's perspective, there's a critical difference, and of course the difference is entirely intentional. It's now that Parliament is supreme and that our own courts are not bound by the rulings of the European Court. So some of the key practical issues for business. The government's going to do a lot of this through secondary legislation. It's obvious that has to be the case. The question is, what's the dividing line between matters of policy and matters of technicality? One man's technicality might be, something that is entirely relied upon by a particular business, some detail of some regulation, which a civil servant, not knowing how important that is, might just say, oh, well, we can get rid of that, we'll try and cut through that nonsense. So that's one issue. One other issue which is going to prove, I think, very complicated is what to do with all the references to European law and community institutions. So to take an obvious example, the Medicines Agency is currently located in the UK, will be relocated. How do pharmaceuticals get authorised and approved? And that's a big issue for the pharmaceutical industry. The point about the courts not having a duty to obey European law, that's clearly going to be the case. Personally, my view is whether or not there's a duty to take account of European law or not probably won't make much difference, because the courts in practice take account of whichever foreign laws they think are going to be useful. And I think they'll find European law continues to be useful even after we've left. But obviously one of the issues for business with a foot in the UK and a foot in Europe will be, over time, the issue of divergence on certain areas of law and the fact that you can't rely on there being consistency in the two markets. And I'll finish with, so one of the issues, I think, practical issues for business is you may not realise that critical aspects of your business rely on particular pieces of legislation. I think the practical issue here is have a think about what it is that is the bottom line. Some of it won't be immediately apparent, and some of it is of general application. So, for example, in litigation, it's quite a big issue. We have currently quite a neat system of enforcement of judgments throughout Europe and recognition, etc. If we lose that, then on both sides of that debate will be additional cost, time, etc. And I'm going to put in, as my final point, a plea for taking the law seriously. It always worries me when people say, well, that's not really a legal question, it's a political question. The danger is that it'll end up being a legal question right at the end, and it might bite people in the wrong place. And I remind, what was the Article 50 case built on? At one level, it was built on the fact that the government could have made the referendum question legally binding, but for whatever reason didn't, regarded it as an entirely political process, ended up being told, well, no, not really, it's also a constitutional legal process. I think inevitably at the end of this process, whatever happens, the European Court will be asked to opine on the legality of the basis on which these agreements have been negotiated and concluded, and may or may not come up with the answer that the politicians want to hear. And by that stage, an already difficult situation could be made worse. So we need to actually sort these issues out now, even if it's quite inconvenient.
Oh, well, hang on, your last point is quite an important one. Because, we're not going to have much time, are we? Paul, I wouldn't mind your comment. If we have to go to the European Court at the end of this, what actually happens? Then is everything, does this clock stop, the 2 years stop? Or?
Well, the bit I missed out was that I talked about Article 50, the 2-year time limit, being extendable if everyone agrees, and that nobody will want to agree. What I was going to say, but I was talking too much, was I think the only situation I can conceive of where people might be prepared to extend it for a little bit, and Theresa May's bought herself a bit more time by not having an election, is if there was a reference to the court. Because they can, I agree with Rob, but they can portray this as, bloody legal nonsense. The politicians have done the deal. The lawyers want to have their say. The only other comment I'd make on what Rob says is, all courts, whatever we say, have political antennae, and they're more or less obvious. The most political court, actually apart from Strasbourg, Theresa May wouldn't thank me for saying this, is the court in Luxembourg. And if all 27 plus the UK have said, this is a good thing and we think this is right, they'd be a very, very brave Luxembourg court to find something different, but they might do.
It would. Rob, is there a chance, and this might affect people here, is there a chance that in the Great Repeal Bill and the whole process, that certain things will actually be forgotten or overlooked, that literally we will arrive on the day and someone will say, oh, holy crap, weren't we meant to provide an arrangement for... It won't be a big one like pharmaceutical approval. Presumably we will remember that we have to we have to come up with a system for that. But, you can imagine small things that will...
Yeah. That's exactly right, and I think that's why one of the things that businesses need to do is to do some checking about what it is that they rely on, because they may find that actually they rely on some very, to everybody else, esoteric little bit of legislation tucked away somewhere. Or the other side of it is they may realise that there are some important, more general things that aren't sectoral to them, but which are still incredibly important to them. The ability to, for example, if you're a business that has to litigate in multiple forum on a regular basis, that aspect of it might be important. That's not probably the best example. The problem is that we can take all of this over into our national law, but a lot of these pieces of directly applicable law or the treaty rights are reciprocal in nature.
Right.
So we can take them into our national law and apply them as a matter of national law, but it doesn't oblige the other 27 to reciprocate unless they've agreed that they're going to reciprocate.
So we might have pet passports, just to take a random example that means a lot to me.
Which works in the UK only. So it's not a passport. There's no point in us
just saying our repeal bill continues the pet passport scheme because it's not our scheme, it's a European scheme.
The only thing I'd say about this, I agree with Rob, one of the things I was going to talk about if there was time was, can the civil service cope with all this? And you can't be a proud bureaucrat for 35 years and not have huge admiration for the civil service as I do. And I'll illustrate this with just one example. I was at a party at DEFRA not so long ago, and I said to this chap, what do you do? And he said, I do bees, which I think is where you got your reference to bees from. And I thought how marvellous that there is one person in the British civil servants who does bees. Now, if you're in the bee industry or the honey industry or the chemical industry, I mean, you wouldn't expect that person to know the details of the bee industry, but what he or she will know is the detail of the way that any EU legislation impacts on bees. So what's going on in Whitehall at the moment as sort of displacement activity until someone at the centre tells them what the plan is, if they've got a plan, is crawling over absolutely everything. You know, getting lists and lists and lists. So somewhere in that list will be bee regulations. So I think that's how they hope to avoid missing anything. But I think one of the things we'll find in the repeal bill, I refuse to call it the Great Repeal Bill, in the repeal bill is a very broad power to say, P.S. if we haven't thought of anything, we've got a power to think about it very quickly and deal with it very quickly.
Yeah, we're allowed to make our own mind up. Rob, just give us a guide, or give the people here a guide as to who they should be speaking to. Okay, they think of things that matter to them, or that may be overlooked, or that are very important. Where do they take that? Is it... Because you could see it could be biz, it could be DEFRA if it's a DEFRA matter, or is it to politicians, their MP, David Davis, civil servants at DexEU? What's the sort of relevant...
Well, in my experience, which is actually largely historically doing this kind of thing in Brussels, is that what you need to do is to find the bee man and who his or her boss is, because what you're really doing is what one could call technical lobbying or legal lobbying or whatever, which is to say to someone, we've got this quite narrow specific issue, this is the problem, and hopefully give the civil servant the solution. But here's the cautionary tale. I did this on behalf of the athletic footwear industry many years ago when there was going to be a quota, and indeed no quota, on Chinese footwear. And at the time, most of the branded sportswear was made in China, and it was pretty important to get something done about this. And eventually we negotiated a carve-out from the quota, which was intended to protect Italian and Spanish footwear manufacturers, for athletic footwear. Well, that process, just that one, effectively 2 sentences, took about a year, cost a lot of money, and almost became highly sort of controversial. So if you can multiply that by thousands of times, the people who
But a lot of it won't be as controversial. I mean, let's be honest, a lot of it will just be very straightforward. It's just a matter of actually having to get done.
Well, the risk is, I think, at best, that people are human and make mistakes and leave things out. So, if you like, the onus is on business to make sure, in their own self-interest, that they know the bits that they must have and make sure they're not left out. And the people they need to speak to are the people who are going to present a solution to their bosses at whatever stage in this process.
Can I usurp your role just for a second and throw this open? Ask for a show of hands. How many of you think Whitehall and politicians have a reasonable understanding of your business, your sector, your industry? Put your hands up if they think you do. Sugar, that's good. It really isn't many.
Well, how many of you don't think
exactly.
Whitehall...
Thank you. He's the expert question.
How many of you don't think Whitehall has expertise?
Yeah.
Okay, so
slightly more, but yeah.
A lot of you are in the don't know camp, basically,
Yeah,
but more of you think you don't think Whitehall has confidence than do. Let's take some points from the floor. We'll take the gentleman in the front here, if we get the mics whisking around, and then we'll take the gent at the other end over there. Yeah, go ahead.
Morning, Christopher McGee Osborne from Denton's, the largest law firm in the world.
Pull the mic closer. That's it.
An interesting point. I've had it on good authority from some of the senior civil servants who are doing this within DexEU and BEIS and DIT. Actually, that the most important thing to do is to get it on every list. If business has an issue, whether it's the beekeeper or the car manufacturer, it's that when the lists get compared, the more lists your issue is on, the more likely it is to get traction. And I share the concern about the capacity of the civil servants, not the mental capacity, but the physical capacity to deal with the volume. As in my experience, what's going on at the moment is that the business department is trying to play the role of uniting business with the right people elsewhere in government. So I think get it to all of the places that you have contact with government.
Right. How do you go about, I mean, maybe you can start us off on this. How do you go about working out which bits of law really matter to you? Because they are like the bones, really, aren't they? You hopefully ignore them until they go wrong. So you may not be thinking about patent law or, I don't know, health and safety at work law, all these things that suddenly may impact on you. So you're a business and you're trying to think which bits of stuff are sort of core to my being.
Well, you've got two bodies of law that you need to deal with. There are the sort of fundamental building blocks, like the recognition and enforcement of judgments. That's not something that matters to you because you're a car manufacturer or you're a pharmaceuticals company. It's something that matters to you because if it doesn't work, your business can't rely on it.
Yeah.
And there are a whole bunch of things like for example, recognition of English law generally across Europe is going to be an issue. So if you're a business with lots of English law contracts, you need to be lobbying to make sure that those are enforceable against assets across Europe.
Okay.
But then you've got the specifics, and you should probably be doing roughly what the government's doing, which is finding every piece of legislation, seeing how they all stitch together, and working out which ones are fundamental to you. There's really no alternative, and your interests there are aligned with government as business,
yeah,
because they want the same thing that you do, which is to start with an understanding of what the law is and what they rely on, and therefore there are real opportunities to help them to understand that. But you're going to have to put in the legwork.
I think the contrast I've been finding, I mean, for example, the insurance sector, is that you're absolutely right that in terms of technical stuff, there are interlocutors within Whitehall who you can engage with. And that's officials at various levels. In terms of the higher level issues of principle, so when Lloyds were saying, does anyone in government care, that we may have to move to Brussels, when AIG was saying, does anyone in government care, we may be moving some of our stuff to AIG, they weren't getting any traction. And that's a different point. It's about the technical legal stuff, which concerns us, but about the politics as well.
Got a question over here, yeah. Just wait for the mic, thanks.
My name is Brian Johnston with the Parliament magazine in Brussels. Two quick questions. The first one, Michel Barnier said yesterday, and everybody's kind of quoted this, I've been talking about Michel Barnier, that the talks, they're not about a good or a bad deal. It's not about a good or a bad deal for the UK, it's about an agreement. And I think at the end of his presentation, Michel also said, Brexit's not the only thing on the EU's radar. Life goes on, and it is going on in a legislative way. I'm just interested in what you think the perception is of what's happening around the kind of rhetorical questions of Brexit from the EU perspective. And secondly, about business. There are, if I'm the British Beekeepers Association, do I go to the European Association of Beekeepers and try and lobby through that direction, or do I try Whitehall? And if I'm the German Beekeepers Association, but I'm interested in the UK market, who do I talk to? Thank you.
I mean, Evan's point was you talk to both sides. You may get a different response if you talk to the EU Beekeepers Association. They're going to have different interests. My favourite one is if you talk to is there an EU Cornish Pasty Society?